Hello and welcome again to the Employment Law Show. Good to have you here for the half hour. John Scholes hosting and my co-host alongside employment lawyer Lior Samfiru. Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. We always tell you, beyond this half hour, you can always reach out to Lior. In fact, you're encouraged to. If you have questions about your work life, employment, if you're an employer, employee, if you've been handed a severance package or you think something's coming down the pike or been put on a temporary layoff, there's a million things that might confuse you in the workplace. Always reach out to Lior. Regardless, 1-855-821-5900, help@employmentlawyer.ca, and a website that was constructed just for you to use. It's free, it's anonymous. You'll have access to the severance calculator, which we'll take out for a spin here in a little bit for sure. A couple times this half hour, that would be pocketemploymentlawyer.ca. Common myths about termination. That's coming up in a little while. That's going to be our main topic for the show, but we always start off things with a week that was a case of the day. Pal, what do you got going on?
Hey, John, great to be here, of course, to talk about employment law as we talk every week to advise you, inform you, and educate you about those workplace rights that you have. We don't tell you about hypothetical rights. We're telling you about your rights, things that you need to know that apply to you if you have a job, if you had a job and lost that job, if you're looking for work right now, need to know what those rights are. This is the time, this is the play, the show where we tell you what you need to know. And of course, if you ever want to take that next step to get some proper advice and sit down and have a conversation, we'll give you that contact information again throughout the show. And as John said, we encourage you to do that. Whatever the workplace issue is, there's solutions, there's answers. And if you're a regular viewer of this show, you're already ahead of many people because you know so much about those rights. And of course, I promise by the end of the show, you'll know even more. And a good place to start, as always, a situation that came across my desk over the past week. Now, I've said many times on this show that you get severance if you lose your job. But do you know you can get compensated if you lost a job before you even started working? Well, I spoke with a lady recently. She had found a job. In fact, she had 2 job offers that she was considering. She was very fortunate looking for work. 2 job offers, a good situation. Well, she accepted one of them and declined the second one. She was very much looking forward to starting that job. Well, fast forward a couple of days before she's about to start, she gets a phone call from the would-be employer, and they say, unfortunately, we're going to have to withdraw this offer. Some things have changed back from head office, and because of that, we're not going to be able to proceed with your employment. Our apologies. Well, she was, of course, very upset, very distraught, especially given the fact that she had another job offer that she declined. And, of course, that was a very big problem for her. So she did the right thing, the thing that I encourage all of you to do, which is she called me. And she wanted to understand her rights. Well, here's the thing. If you get a job offer, if you accept it, and then by accepting it, you lose on something else. In this case, she lost on another job offer that she had. Another loss could have been if she had quit her job. Well, if you lose something because you're told you have an offer, well, that company now has to compensate you for your loss. So in this situation, at the end of the day, they'll probably owe her a couple of months' pay, even though she never started working. So the bottom line is an employer can't just withdraw an offer after you started working. And certainly they can't do that without consequences. So you may have rights if you accepted a job, if that job has been withdrawn. And of course, beyond that, you know this already. If you were actually working, even if it's for a short period of time and you lost that job, yes, you're going to have significant entitlements.
If it was a case where she was being pulled from another secure job, she didn't want to leave. She didn't plan on leaving. She just figured, okay, this is a good opportunity. I'm going to take this one. And same scenario, this would-be employer last minute goes, you know what? Sorry, we don't need you, back to the old place. If she was at that previous job for 25 years, is that new employer that was almost her employer, are they going to be responsible retroactively for a quarter century worth of severance?
Absolutely.
Wow.
So absolutely. If she had been in a job for 25 years and she quit that job to take this new employment, and then, sorry, we withdraw it. Well, no. You have to compensate her for her losses, and that's the equivalent of, let's say, 18, 20, 24 months of severance. It could be huge. It could be very significant. So employers have to be smart. Don't make a job offer unless you know for a fact that it's set in in stone. It can't be changed. Or guess what? You may have a very significant bill you're going to have to pay.
And that's even before she stepped foot in the actual new workplace. She hadn't started there.
She hadn't started. She'd been days away from starting. No, there's significant consequences here. It doesn't work that way. If someone loses something because of something that employer did, well, that employer has to pay.
Now, on the employer side, is that something where the employer in an employment contract would say, we're not going to recognize previous service, try to save themselves a few bucks if that came down the pike?
So anytime, John, an employer recruits an employee from another job, there's that risk for that employer that they're going to inherit that service. And that could be many, many years, even decades of service. So if we're looking at it from an employer standpoint, if not from an employee standpoint, but from an employer standpoint, anytime an employer recruits an employee away from another job, they should have a term in the employment agreement that either limits future severance or that specifically says we're not recognizing any time, any service with any other company. If an employer doesn't do that, well, guess what? They're exposed, which again, for the employee, that could be a very good thing.
All right, guys, the website anytime, employmentlawyer.ca, good place to go. Lots of information to be had, contact information with Lior and his team, of course. And on the media page, you'll find a radio station close to you somewhere across the country where you can catch our radio programs, either half hour or an hour, depending on what market you're in. Get a lot of phone calls every week. We love it. Like you listening to this show, they decide to call into the radio show, say, I got a question. So we get those on air. We talk about them. Then we cherry pick a few of them, right? We play them back here. We talk about them to break it down a little bit. So we'll get to our first phone call from one of our radio shows right now.
I was terminated effective immediately after 7.5 years employment, and I was given kind of packaged to go out with 10 weeks pay, and my benefits went on. And I was there for 7.5 years. Does that seem like it's a good deal?
What kind of a job were you doing there?
It's retail.
Retail? And how old are you?
I am 62.
Most people, you walk the street, most people would say, yeah, that's more than a week per year. Great deal. Walk away with it.
Took the words out of my mouth. I bet you if we ask people that don't watch this show,
right,
if that's a good offer, after 7.5 years, she was offered 10 weeks. That's more than a week per year. Yeah, that sounds actually pretty good. It's pretty generous, one may think. Well, I know that the regular viewers of this show are shaking their head now because they know what I'm about to say, and that is absolutely not. That's not a good offer, that 10 weeks after 7.5 years. That's a horrible offer. That's a fraction of what the person is owed because there isn't a rule or a law of a week per year of service. It's a lot more than that. But how do you actually know the real number? Well, we've said it before, we'll always say it again, and that is we have our severance calculator tool. You can find that, of course, at pocketemploymentlawyer.ca. So let's use that tool right now, and let's get the real answer, the real severance that this person is owed. So we're at pocketemploymentlawyer.ca. We plugged in the information. So this person been there for 7.5 years, 62 years of age, was only offered 10-week severance, but you see right at the bottom there what she's actually owed. The real amount is 8 to 10 months of severance. 8 to 10 months. That's a huge, huge difference. That's why we have our severance calculator tool. That's why everyone should use it.
It's interesting, though, the job, not super high-end, the amount of work time, 7.5 years, not a huge amount of time, but that severance is pretty robust. It's got to be the age. She's 62, right?
Age is one of the big factors, one of the big three. Age, position, length of employment in terms of how much severance someone is owed. So the older you are, and of course, the longer you work and the more senior your position, the more you are owed. And in many situations, the law understands that it may be more difficult to find a job maybe at 62 than it would be at 42. And that's why the severance is intended to compensate for that. So severance is going to be more. So yes, 10 months for her would be quite reasonable, John.
In addition to radio and TV and actually practicing law, Lior does a lot of live streaming as well. Those you'll find on YouTube and LinkedIn and Facebook at stlawyers.ca. We'll get to a question from the live stream now. Lior says, I was working at the same manufacturing company for almost 3 years. Unfortunately, I was part of a large layoff due to restructuring and cuts. My employer informed us we will not receive severance as they are struggling financially. Is this legal?
No. It's not legal. The law does not make exceptions or provide exemptions for companies that may be struggling financially. You have to comply with the law if you're operating a business in Ontario. Full stop. It's as simple as that. So you don't get a get-out-of-jail-free card just because you may be struggling financially. And I understand that many companies may be, and certainly during the pandemic, many companies have struggled financially. That does not change the law. So in this situation, that company still has to pay. And if it won't, the law is going to come in and make them pay, and can even enforce against assets that they own and equipment that they own and accounts receivables, etc. So no, a company still must pay. Now, of course, if they're in actual bankruptcy, then unfortunately that could be a very bad thing for employees. But the fact that the company may be struggling financially is very different than being bankrupt. So yes, you still have to pay.
And I was going to say the one term in there that was not mentioned, they said struggling financially. That's different than bankrupt, right?
It's different than bankrupt. It's different than insolvent.
Right.
Struggling financially means you still have to figure out a way to meet your obligations. And the obligations to pay severance to those employees are some of the most important obligations an employer has to comply with. And of course, that could mean as much as 24 months severance per employee.
As I mentioned off the top, our main topic for today is common myths about termination. We'll get to that, but we're taking a short break first. In the meantime, here's the number to reach out. Contact Lior. That is 1-855-821-5900. help@employmentlawyer.ca, and that website, right? pocketemploymentlawyer.ca. Lots more. The Employment Law Show is on the way. Stick around. We're coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And thank you so much for sticking around. This is the Employment Law Show. We love doing this every week, and you joining us and learning so much. You can always reach out after the show. You're encouraged to, as we tell you every week as well. Phone Lior and his team, 1-855-821-5900. Emails help@employmentlawyer.ca or the website pocketemploymentlawyer.ca. That thing was created with you in mind to educate you even further. Before you pick up a phone and ask any questions, you can use that website. It'll answer a lot of things for you, and you'll have access to the severance pay calculator as well. Okay, common myths about termination. That's the main topic for today. Number one, Lior, an employer can't fire an employee unless it is for a legitimate reason. What do you think about that?
So we're talking about myths. So the things that you're going to list right now are myths. In other words, they're not true. And a good place to start is this idea that an employer has to have a legitimate reason. And I can tell you, John, that most of the time when people call me after they lost their job, they call me because they don't think the company had a legitimate reason. And you know what? When I listen to them, I tend to agree often. Yeah, it doesn't sound like the company had a good reason or that the decision to let you go really made any sense. But the question is, do they have to have a legitimate reason? And no, the answer is they do not have to have a legitimate reason. An employer is allowed to let an employee go for good reason, bad reason, no reason, as long as severance is paid. That's why you hear me on the show say that word severance so often. It's not because that's just what I want to talk about. It's because that's what the law does. The law can't make your employer make better decisions when it comes to letting you go, but the law can absolutely make sure your employer pays you your severance. So you can be let go even if you've done nothing wrong. You can be let go even if the company gives you a reason and it turns out that reason is false. Maybe they're saying they're restructuring and they're not. Ultimately, they can do that. It's not a nice thing to do. Maybe it's even unethical, but it's not illegal as long as they pay severance. So that's what we always talk about here, because severance has to be paid. In most cases, as we've talked before on the show, severance, proper severance, is not paid, which often makes it a wrongful dismissal. But the law deals in severance.
Termination myth number two is this one. Employees can be let go for cause due to mistakes or simple errors and will not receive any severance pay at all.
So this is another concept. We talked about being let go at all time as long as severance is paid. In some situations, an employer can let you go without severance, but that's only if we can say that you were let go for cause. In other words, you did something so bad that the company can just decide to let you go and not pay you anything. But the myth here is that maybe just because you did something wrong or you made some mistakes, you can be let go for cause. Absolutely not. That's not enough. You cannot be receiving the worst penalty, which is a termination for cause, just because you did something wrong. You would have had to do something terrible, something so bad that there's just no way for the company to continue employing you. And I've seen this many times, hundreds of times over my 20 years of practice, where a company supposedly says and tries to let the employee go for cause and tries to avoid paying them severance when they cannot do that. So yes, if you stole, if you hit someone, if you committed fraud, yeah, you can be let go for cause. You're not going to get severance. But if you haven't done that, maybe you were late, maybe the job you did on the project wasn't so good, maybe your numbers are down, that does not mean you can be let go without severance. You're still owed your full severance, which can be as much as 2 years' pay.
We are talking about common myths as it pertains to termination. Number 3 is this, Lior. Employers only need to give someone the minimum amount of severance when they're terminated.
Big myth, one of the biggest myths. The reason why I have 50 lawyers across this country is because of that myth that employees and certainly employers believe that, well, as long as we comply with minimum requirements, that's all we have to do. Nonsense, not true. There's minimum entitlements that an employer has to comply with, but that's irrelevant. Your full entitlements are still legally required. We call those common law entitlements when it comes to your severance, the compensation that you're owed when you lose your job. So yes, if you lost your job after 5 years, your minimum entitlements, as an example, could be 5-week severance. But forget about that. Your full entitlements could be 12 months severance. So it's not enough for the company to comply with the minimum. They have to, by law, comply with your full entitlements. And by the way, that's why we created the severance calculator, so you can use it and find out what those full entitlements are. Of course, that's at pocketemploymentlawyer.ca.
We're talking about myths of termination. These are untruths. Number 4, got a couple more there, so let's keep going, Lior. Employees on a contract are not entitled to severance pay if they're let go.
False myth, absolutely not. Now, on contract may mean that you're on a fixed term contract, that you're there for a period of time, a specific period of time. On contract may also mean that you're not really an employee or a contractor. In both those situations, you're going to be owed severance if you lose your job. It's rare for someone to truly be an independent contractor. Most of the time, people are misclassified. And if you're on a fixed term contract and you lose your job before the end of the contract, the employer still has to pay the balance of the contract. So yes, being on contract doesn't mean you don't get severance. In most cases, if you lose that job, even if you're quote unquote on contract, severance has to be paid.
All right, termination myth number 5, last one for the show, guys. Here it is. Short service employees do not have the same rights and severance entitlements as long service employees.
False. In fact, the opposite is true, and that is that long service employees actually disproportionately get less severance than short service employees. You actually get disproportionately higher severance as a short service employee, because the law understands that just because you work somewhere for a short period of time doesn't mean you're going to find a job immediately. Not at all. In fact, it may be more difficult. So you can get a few months severance even after you work for a few weeks. So definitely you have to understand that short service doesn't mean little severance. In fact, the opposite is true.
We take a ton of phone calls, as I mentioned on our radio shows. They happen throughout the markets in Canada. Just go to employmentlawyer.ca to find a station near you that carries our show. And you can call into the show as well and ask your questions live, which is kind of cool. We'll play them back here. And we'll get to phone call number 2 from our live radio shows right now.
I started a job 3 months ago with a new company. They did send me an example of what my contract would look like, but they never actually sent me my contract, and I never signed anything. So I'm curious to know if it's in my best interest to continue working without a contract, or if I should bring it up to the HR and have one signed.
No.
Yeah, so John is right. And I remember this call from our radio show, John. Absolutely not. She is fortunate.
Yes.
She is fortunate that her employer never asked her to sign that contract. And the reason for that, for the employee, it's so much better not to have a written contract, to work on what we call an oral agreement, or even something on the back of a napkin. What a contract does, and I can guarantee you that almost, is it takes away rights you would otherwise have, and either takes it away, eliminates them, or turns it around and gives those rights to an employer. By not having a written contract, that means you have the full protection of the law because you haven't given up your rights. They're there for you. So no, if you're started a job and you were not asked to sign an employment agreement, consider yourself fortunate, and certainly don't be going out there asking for it. I'll take it a step further. After you started working, if your employer comes to you and says, I want you to sign this agreement now, be concerned. That's not a good thing. Let's talk about that. Let's review it. Let's make sure you understand what you could be giving up by signing that agreement. Not a good thing to do.
Generally, if she's already started, though, does it still have the same sort of gravitas that it would if she signed it previous to stepping through the door?
Well, if you've already started working and
Right.
your employer wants you to sign a new employment agreement, they have to do some extra work. They have to do something else for you in order for that agreement to be enforceable. They have to give you something, a signing bonus, an extra vacation, a pay raise, something else. We call this consideration in legal talk, in order for that agreement to be enforceable. That said, I'd park that issue aside. Don't sign an agreement that you're not prepared to live with. And the starting point is always, what does it do? What does it say? Happy to help you review that so you can understand what you've been asked to sign.
Great phone call, but we'll want to get to one more. We'll do it on the other side of the break. So in the meantime, you can write this information down and keep it after the show as well. 1-855-821-5900. The email to reach out is help@employmentlawyer.ca. And we'll continue with more of the Employment Law Show. Hang on.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, Employment Law Show. Thank you so much for joining us this half hour. You can always give Lior a phone call, talk to him or a member of his team anytime, 1-855-821-5900. The website, employmentlawyer.ca. Knowledge Center, drop-down media page. That's where you want to go to find a radio station in a market close to you, where you can tune into our show every week. You have the opportunity, of course, to call in live and ask your questions. Phone call number 3 from one of our radio shows, Lior, is coming up right now.
Worked for a company for over 10 years. I might be getting forced into a new role, and if I don't accept that, I might get laid off. Now, there's somebody in my company that worked for this company for 20 years in a similar position as myself, and the company just offered them the 22-week severance. My salary is $70,000 to $90,000. What am I owed after 10 years if I do potentially get laid off?
So this is actually an important call because oftentimes you hear about your colleagues, hey, everyone has been offered this, so it must be right. If everyone has been offered 5-month severance, that must mean that that's all I'm owed because the company must know what it's doing. They wouldn't offer everyone bad severance, would they? Well, yes, they would, and yes, they have, and yes, they will. So it does not matter what everyone got. It doesn't matter what the company says you should be owed. It's your job to determine, is it right or are you owed more? And I can tell you that in over 90% of cases, regardless of what everyone received, what the company's offering is less than what you're owed. And not a little bit less. Maybe we could kind of look the other way if it was just a little bit less. It's a lot less. So this is a prime example. Let's actually go back to our pocketemploymentlawyer.ca tool. Let's use our severance calculator and let's actually see if what I said is right here. So we know that this person has worked there for 10 years. He's been there, let's say he's in his 40s, and the company says, hey, 5 months, that's 22 weeks, that's all you get. Well, you can see right in the bottom that that's potentially less than half of what he's owed. He's owed up to 12 months, not weeks, months of severance. So more than double what they've offered him. So that's an 100% improvement that he needs to get here. That's why it's so important to go to pocketemploymentlawyer.ca or call me or do something before you accept that severance offer.
So in the situation where there's mass layoffs or mass firing, say there's 15 people, everyone gets a severance package. Maybe they are similar, maybe they're all the same. Out of 15, how many people would know to call you and say, Lior, something smells wrong here?
You know, unfortunately, of the 15 people, probably less than 5.
Wow.
You know, 3 or 4 maybe will call. So from the company standpoint, that's kind of good odds, right? If we're going to let go 15 people and we'll offer them all less severance than what they're owed, 10, 11, 12 of them are going to accept that. That's not bad. That's why often companies do that. But you can't worry about the other people. You have to worry about yourself. That's why you're watching the show. Now you know better. So you're going to be one of the people that doesn't get less severance because you know.
One more website you can use anytime, terminationquestions.com. Again, terminationquestions.com on your laptop or your cell phone or your desktop for that matter. You can use it, ask your questions. It might appear on a future show like this one. It says, Lior, after I failed to meet a project deadline, my manager suggested that I could be put on probation. Can you be placed on probation years after you were initially hired?
You know, I get this question often, and, you know, I've been working there for a while. Maybe I made a mistake, or maybe my employer's not happy. They want to put me on probation. What does this mean? Well, the reality is it really doesn't mean anything, because if the company wants to let you go because you're on probation, you've been there for years, they still have to pay you the severance. And the fact that they're calling you on probation doesn't change that, doesn't reduce your entitlements, doesn't give them new rights. So if it makes the company feel better by saying, hey, you're on probation, okay, that's fine, have at it. It doesn't really change anything from a legal standpoint. So the important lesson here is this. If the company puts you on probation, don't lose any sleep because it doesn't mean anything. But if you end up losing your job, if the company says, hey, we put you on probation and you didn't shape up enough to the point that we want to keep you, so we're going to let you go, well, we already know they can't be stopped. But guess what? They still have to pay your full severance up to 2 years of pay.
Get to one more question through email here. Lior says, my doctor has given me restrictions and required accommodations for my return to work after my insurance company forced me off my long-term disability benefits, my LTD. When I told my employer, he said they were unacceptable and I should consider other employment. Is that legal?
Oh,
nice eye roll, by the way.
Yeah, I mean, right off camera here, I was rolling my eyes because this is, number one, it's a ridiculous thing for an employer to say, but worse than that, it's a common thing that I see all the time. No, it doesn't work that way. The company doesn't get to say, too bad. The company doesn't get to say, we're not going to accommodate. The company doesn't get to say, you should look for another job, okay? We have laws in this province, in this country. Frankly, when it comes to human rights, our laws are the same in any province in Canada. And that is, if you have restrictions, as long as you have that all-powerful tool, which is the doctor's note, your employer has to accommodate, okay? They have to provide that accommodation. They have to find a way to make it work. Maybe that means modified duties, less restrictive duties or more restrictive duties. Maybe you don't have to lift as much or stand for as long. Maybe it means modified hours. You can work, you just can't work 8 hours a day. Maybe it means working remotely. It's just getting to work that's a problem. That's the restriction that you have. Whatever that restriction, the company has to find a way to make it work. And if they don't, that could be a human rights violation. That could be an employment standards violation. That could be a wrongful dismissal. You name it, illegal. So if you're ever in a situation where you've given that doctor's note, you're looking forward to being accommodated as your doctor says you should be, if the company doesn't do it, you have to give me a call. Oftentimes I can get the company to understand that they have to accommodate, or if they still won't, there's very significant consequences that are going to be there.
If I look through the employer lens, how high is the threshold for that accommodation? How far do I have to go?
Now, at some point, it may be so difficult, so costly, so problematic to accommodate that the company doesn't have to go that far if it's really, really bad. Unfortunately, in many cases, the company doesn't work hard enough to try to accommodate. They jump to the conclusion that it's too hard right away. No, it's a very high bar that the company has to meet. If they don't meet it, again, that's easily a a human rights violation.
And again, the bar is higher, the more robust and more money that the company has, if it's a larger company, right?
A big company with a lot of resources, a lot of employees, and frankly, a lot of money is going to be expected to do more than a tiny little organization with 1 or 2 employees. But that duty to accommodate will apply across the board.
And that is it. Thank you so much for your contributions on phones, emails, etc. You want to reach out now that we're done? No problem. Use the phone. First off, 1-855-821-5900. That email address is help@employmentlawyer.ca. And always use that website, pocketemploymentlawyer.ca. You have free and anonymous access to the severance pay calculator as well. We'll see you next time in the Employment Law Show.